All right, good morning, everybody. It's 9 o'clock on Thursday, September 26, 2024. This is the Policy and Procedure Committee meeting. Call the roll, please, Amanda.
Ducat, Behrens, Alt,
Here.
Whitlow,
Here.
Sure.
Yes. Everyone have a copy of the agenda in front of them? Do we have a motion to approve it? Okay, second by Mr. Barron. Are there any questions or comments regarding the agenda? If none, all in favor say aye.
Aye.
Opposed, same sign. That motion carried. Do we have any public comments? None, we'll go on to the EMA report, Mr. Anderson.
Good morning, everybody.
Morning.
No incidents, thankfully. Hazard mitigation plan meeting October 24th. That's going to be our last planning meeting. Forward from there to the last, there will be other meetings, but the last planning meeting still, completion date remains to be July of next year. Quite a bit on training this month, mainly because I attended the training summit first week of September. I went to the days, the pre-summit and post-summit, which is the day before and the day after, because of things that they were holding. The pre-summit meeting was a 4-hour meeting that was focused on the LEPC, the local emergency planning committee that we have. I learned a lot more than I have in the past because I really haven't had a lot of time to focus on that. But one of the biggest things that I learned there is I can take advantage of a separate grant, the Hazardous Materials Emergency Preparedness Grant, which isn't funded by FEMA, it's funded by the Department of Transportation. And basically, if you have hazardous materials that go through your jurisdiction on either wheels or rails, you qualify. Well, I guess we do. So beginning part of next year, I will be applying for that grant. One of the biggest advantages is it will pay for a lot of training in regards to that, helping. It is the current grant that we operate under with EMA is more designed around what would be preparedness. This is just designed around response. So I'll be able to involve the fire departments and everybody and working with the railroads or trucking companies, be able to provide true hands-on training for what would be a response to an incident as a report, as opposed to just would be preparedness. The other portion of that is, and I made the call to the coordinator for the state, because this is an IEMA grant, it's just not funded by FEMA, it's funded by IDOT. The remaining portion of what is my annual salary, half of it is which is provided by grant we under currently. The remaining portion of that may be able to be funded by this grant. So at least a good portion of it should cover my salary in this position, therefore taking it away from the line item, the taxpayers. So I'm going to work more with that. I went to the regular weekly trainings, the ones, learned a lot. Post-event, I attended the Stop the Bleed training, mainly to get current knowledge. I was a paramedic for more than 20 years, taught trauma protocols, but I thought, what the heck, let me see what new could be out there, and I took their class. I learned a little bit more, but the biggest thing that I learned from is I could be an instructor. So I went, followed their protocol. This is a Department of Defense initiative class. And I followed their protocol online, took the online training course, and then filled out the application. And although it's geared toward current healthcare providers, paramedics, CMTs, nurses, there's another box, and I checked it and I put in my previous experience, sent off my application, and within an hour and a half I was accepted as an instructor, which was handy because I found out just a couple minutes later on a whim in the hall talking with Lieutenant Moorfield from the Sheriff's Department that they're seeking an instructor. They couldn't find anybody to teach this class that was local. And I told them I literally just got that certification. So I put in a purchase order, purchased the required hands-on training materials. I should have them in the next couple of days, and I'm going to then go forward and teach and certify all of the members of law enforcement and then the sheriff's department. Then I'm going to expand out to the local police departments, what Zika is interested. And then once all law enforcement is trained, I'm going to shift gears and I'm going to start heading towards the schools.
Make
Already.
sure you charge them enough.
There's actually, there's no cost with this, but I can, if I open it up to the public, which is possible, I can charge a fee to cover what would be my expenses, and its average is about $30 a class. So in the initial onset, just to get the required people like law enforcement and the like, that kind of stuff, the Department of Defense, they don't want you to charge a fee. But you can if you're going to open it up to the general public. So, but yeah, I plan on teaching it to the schools as well. But I also have some people that are interested in stepping up and being instructors. So that would aid me with that. So we can move this along. It's a big initiative that's been pushed for several years. At the same time, our ARPA grant was open. I submitted an ARPA grant application for what would be the training materials. It's less than $3,000, but I think that I'm hoping that the committee will look at this as a significant benefit to what would be the county and the life-saving potential that it would provide. So, moving forward, the training. One more. I did take a 8-hour class that was specific to sheltering and relocation. I learned a lot more from that, which will help me adapt our correct EOP annex on that. I'm glad that I took the time to spend that 8 hours. Our county emergency operations plan finally got some direction from the state. All the counties have been in limbo waiting to hear what the state's going to require for all of the local entities to have in their emergency operations plan. We've known for a while that changes were going to be implemented. We now have some guidance. They're going to require 10 separate annexes which relate to the top 10 hazards and threats that are identified locally. It's not a big deal to add these to the plan. We don't even have a date when the state's going to require those to be done by, but I've already got work started on it, and my EMA volunteers would have been working with me on the plan. By the time we have it done, we'll probably be completed with that before the state sets the required deliverable date. For training, haven't held anything in the past month, but I'm going to be planning a training meeting that will open the invitation to all the different fire departments, police department, anybody that wants to at least be part of the planning meeting. So it'll help me get direction on what these people want to be trained on. And it's also a requirement in the IEMA process. So committee meetings, LEPC meeting will meet in October. We will also, that's when I mentioned it last time, Marvin Stignott requested to resign from his vice chairman, so we'll address that. I go to the Amateur Radio Club's meeting tonight. We're going to discuss, they should have purchased the radios that they got the money from the Griffin Trust. So if all that's in place, I'll be putting a press release together for that. We can start having them distributed to people that can't afford them. I had a scheduling conflict last night for Mavis, but there was really not much on the agenda. I just made sure that they were aware of the upcoming planning meeting. Again, the NIMS training, I encourage everybody to go ahead and take that. It's got a certificate today. We do have people that are volunteer. I appreciate good knowledge. And again, volunteers working with me on getting the EOP in line and social media. Not much went on this month, but still we're averaging about 25 new followers every month as we go along. So that's it in a nutshell. Any questions?
Do you have any questions for Mr. Anderson? Good luck.
No problem. Thank you.
Move on to the committee chair report. Begin with Mr. Barron's and the management committee.
Make some reports on board and that. Other than that, there's not a whole lot going on. Regular reports.
All right, health, tax, and zoning, Mr. Duquette.
Start with health, it's easy, normal reports, nothing going on. I haven't heard of hiring yet. For anybody yet, is that correct?
Right, that's next week, I think we're looking at that.
Okay, fantastic. Tax, we'll be going over the wind, solar, and battery storage ordinances. Maria's getting ready for the upcoming election. And then ARPA, we'll be going over new applications and processing through those and doing the best we can to make sure the county is taken care of all area wide. And then hopefully helping the offices in there too.
Okay, excuse me, Mr. Whitlow, judicial.
The sheriff reported that got 2 correctional officers that completed their training, so they're now fully certified, so that helps them a lot. Another investigation was still ongoing on the incident that happened to the Newton County sheriff, sheriff's deputy, and Investigator Watts and the sheriff are doing training different schools for the intruder shooting or any kind of invasive action that may come upon schools. So they're hitting the schools up on that right now, which is all good. Unusual reports other than that.
Okay, Mr. Hall, highway.
Alan didn't return my call of what was to be planned this week, so I don't know what's going on. I know we'll have the normal things, but I'm not aware of what, if anything special coming up.
Okay, finance, Mr. Barron.
I gotta be with the final touches on the budget.
Got approval to get it posted?
Yeah, I think that would be the plan.
Okay, very good. So move on to chairman comments. I have one bit of news for everybody. It's really exciting. As you all may remember, years ago, we had Head Start here in the building. And we got in a situation where they left the building and they've been out of Jefferson Plaza under the auspices of the East Central Illinois Action Agency down in Danville. The people in Danville have lost that authority to run that program. So it's being taken over by the Champaign County Regional Planning Commission. And we have some prior experience a number of years ago with them. They used to be a tenant in the building, matter of fact. So they are planning to take on this beginning November 1st. And they are asking that we enter into an intergovernmental agreement with Champaign County for this whole thing. And I have a copy here of the intergovernmental agreement and a letter with it, and if anybody would care to review that, that's fine. But the intergovernmental agreement that's attached to that, I want that given to Mr. Devine so that he can review it and give his approval of it. We will not have it on the agenda of any committee meetings. It'll just be on the agenda at the county board meeting.
Are you saying that they want to move back?
No, no, they're going to continue to operate out of Jefferson Plaza. They will not be moving back into this building. We don't have space for them at the present time.
I'll say it's all taken up.
I think it's a program that needs to be conducted. The only requirement that we're being asked, the whole thing would be that we have one county board member to be a member of the oversight committee. I forget exactly what they call it, but anyway, we have to have a county board member that will be a participant in that program. So. The woman that signed that there, Tammy Ogden, will be at the county board meeting on October 8th to answer any questions that people have and so forth.
Put that further sometime.
Anybody?
I questioned their security while they were here. I hope it's improved.
The only thing
They're not
this
gonna be
is-
here, Charlie.
Well, even in the county.
The only thing that this is asking for is for a board member to be on their board, so.
You hand that to Mr. Devine. Look it over, and if he approves the intergovernmental agreement, we'll have it on the agenda at the board meeting on October 8th. That's all I have for that, so we'll move on to the next item, discussion and action on the show bus intergovernmental agreement. It's our last meeting, there's been a few developments that have occurred that I guess I need to make everybody aware of. I attended a meeting in Ford County. It was on the day we had our last finance committee meeting, I don't remember the exact date of it, but anyway, I had a discussion with them about what their plans are going forward and so forth. They appear to be between the outfit from Vermillion County and going with Kankakee County. I think just to make sure everybody's memory needs to be jogged a little bit, we had four different options. One was for us to put together a program on our own. Another one was to join with Livingston County and Ford County to put together a program. And the third option was to join with Vermillion County, and the fourth one was Kankakee County. The first two options I don't think are viable, and I believe everybody pretty well agrees with that. If they don't, they should speak up so that we would know that. I think in reviewing everything, probably moving to join up with Kankakee County makes the most sense. In order to get that done, we have to get going with some activities on their part. One of the things that we did was we sent a FOIA request to McLean County to get records. And what they sent back to us here in this book, out of paper in here. It doesn't really tell us a whole lot. It doesn't give us the information that we really want and need, which is the revenues and expenses involved in so far as this particular county and even the whole program is concerned. So there still are a lot of questions that need to be answered. My opinion at this stage of the game is that we should be pursuing an agreement with Kankakee County. They are receptive to this. However, they would like to get a letter of intent from us. It's a non-binding letter, but it demonstrates to them our interest in wanting to join with them. And so I'm looking for a motion this morning to do just that. Mr. Ducat is making that motion. Mr. Whitlow is seconding. I can get together with Mr. Devine and we can see about constructing a letter of intent. It shouldn't be anything that's really lengthy in any way, shape, or form, but we need to get going with this and we need to get some things put together. We're still not getting information from the state that we need. Senator Bennett sent an email last Friday to the head of the Department of Transportation to again request the information that we need. Haven't heard a response even to that yet. It's kind of a very difficult position and situation to try and get into something where you don't know what the facts and figures are. We have some facts and we have some figures, but trying to put it all together is, when you're not familiar with the operation, it makes it all the harder. But like I said, anybody that wants to look at this book, Amanda was kind enough to assemble all this. It's available for anybody that wants to look at it. Anybody else have any questions or comments on the show bus map? Anybody in the audience have any questions or comments about it?
Is there any money that's gonna be asked of Iroquois County in joining with?
We don't know that yet. Obviously, there hasn't been any in the past, and we'd like to keep it that way because we really don't have any money allocated for that purpose. If we had to allocate money to it, it's gonna pinch us pretty hard someplace else. Mr. Watts?
Was there any other contacts with, for instance, Champaign or any other county, or just Kankakee?
What other county would you think? We have to be contiguous to the county that we join with. We're not contiguous with Champaign County. We are contiguous with Vermillion County and Ford County and Kankakee County.
Yeah, that's what I'm asking, was there contact with any of those others?
Well, since we're not contiguous with them, we wouldn't be able to join with them. The state requires that you have to be contiguous in this particular instance, with the county that you join with. So we can join with Kankakee County because we're contiguous with them.
Vermillion has had somebody here and we've talked in the talks.
Okay.
They gave a presentation.
You've been here a few times, Scott, when that other lady was here from down from Vermillion. She was here talking.
There may be other counties somewhere in the state that might be interested, but if we're not contiguous with them, we can't do anything. We're limited.
We know what Ford County has done.
I know that they've talked with Kankakee County, and I believe there's a good level of interest there, but I don't know that they've reached any decision yet.
So they're in the same position we are.
The person that I have the best contact with in Ford County was out of state for a while, and so I'm hoping to get back in touch with that person in the next day or two to get a better update. But my feeling is that they probably will do what we in Livingston County are gonna do, because they're kind of sandwiched in between the two of us. But they are contiguous with Vermillion County as well, so if they choose to go that way, they do have that option. I think part of the problem with all of these things is where the populations in the counties are, where they go when they go outside the county and so forth. And there is no perfect solution. In our county, people from somewhere around Highway 24 and north all go outside the county to Kankakee County for a lot of their medical shopping and those kind of activities. People in the south end of the county go south. Ford County is kind of the same way. They have people in the north end of the county, population-wise, not a lot, but those people don't go all the way down to Champaign or someplace like that to shop. They go north to Kankakee. So trying to meld all this together is always going to be a problem. There's no perfect solution. There is, when you look at the bus routes that exist right now, though, there is a bus route from here that goes down to Danville. I believe it's once a week. There's supposed to be another bus route that goes to Pontiac, as well as bus routes that go up to Kankakee. So I think trying to maintain that type of a situation is in our best interest and will serve the majority of the people in the county. Unless anybody else has any questions or comments, we'll move on to our next item, which is the,
I spoke to roll call.
oh, excuse me, I got carried away. It really probably would be good to have a roll call, I guess.
Dugat,
Yes.
Barons,
Yes.
Alt,
Yes.
Whitlow.
Yes.
Sure.
Yes. Okay, excuse me for that. Proof out there. I'm anxious to get into the county code book.
I can feel it.
That's our next item on discussion. Pleased to have our state's attorney with us this morning. We'll hopefully answer any questions or comments that we have in regard to that.
They need to stay then, or?
I figure, I mean, how long is the code? You got executive session after this, right?
Yeah, we're gonna be done at
This is gonna be now.
Okay. Promise is promise. Well, I appreciate everybody's time today. Just for the chairman, we're gonna try and get all the chairmen together. Craig Long, who's a county board member from P&P, was here at the last meeting. He's on vacation this week, but he'll be back in a week, and we're gonna try and sit all the chairmen down and kind of talk through some of my board had a lot of questions the same way you guys have lots of questions, so we're still working with IDOT trying to find a solution, but we'll get something set up probably middle next week, so.
We need to get going.
Yeah, sooner rather than later.
Okay.
All right, thank you.
Okay, county code book. Chapter 14. Has to do with the court. Fortunately, Mr. Devine, with his great expertise in these matters, can help us know that what we're doing is correct, right, the way it should be, and all that sort of thing. The first section in chapter 14 has to do with the court security fees. In the past, I've read through these things. I guess I'd like to continue that, but I'll read kind of quickly in the interest of time. Paragraph A says in all civil cases except those having a statutory exemption from fees, fees shall be on file in the county clerk and recorder's office and shall be payable by each party at the time of filing their first pleading or other appearance, with no additional fee to be paid if more than one party presents a single pleading or other appearance. Provided, however, that in small claim enforceable entry and detainer cases, the fee shall be on file in the county clerk and recorder's office. My question on that, is that the way we're doing it now?
I presume, I know they're collecting a court security fee, that's how the security officer in the front is being paid. So,
But they pay it to the circuit court, do
well, it's paid, but this is saying that it should be on file with the county clerk as far as, I think it's more, the recording needs to be in file with the county clerk. It's paid at the circuit clerk's office to.
I know when we talked to the county clerk about this and some of the other areas, she says, I have no.
Right, she wouldn't have any idea. It just says that
That's the reason we want to get that clarified.
I don't know what it means by the fee shall be on file. It doesn't say anything that it, to me, it's more of an ordinance matter than it is the actual collection of that fee. I know the actual collection of that fee is done by the circuit clerk. 100% sure of that. And that's the way it's been forever. So that's how I read this, is that, you know, the fee shall be on file in the county clerk and recorder's office. I wouldn't hesitate to put it to the circuit clerk rather than the county clerk, because really, what's the point? Because the county clerk's the one, or the circuit clerk's the one collecting. So if somebody wants to question the appropriateness of that fee, they can talk to the circuit clerk.
So are you suggesting we change the
Yes.
county clerk and recorder office to the circuit clerk?
Yeah.
Okay. Everybody agree with that? Okay, we'll move on to subparagraph B. There should be no fee required of a defendant where he files an entry of an appearance and does not serve summons, where the sole purpose is one of obtaining jurisdiction over the defendant. Fee is also waived for guardian and items and for all parties who enter their appearance in probate proceedings.
That's fine.
That's correct?
Yeah.
Okay. Paragraph C, in criminal, local ordinance, county ordinance, traffic, and conservative cases, fee shall be collected upon a plea of guilty, stipulation of facts, or finding of guilty, resulting in a judgment of conviction or order of supervision or sentence of probation, without entry of judgment pursuant to the Cannabis Control Act, Illinois Controlled Substances Act, Criminal Code of Illinois, Alcoholism and Other Drug Dependency Act, or Steroid Control Act, imposed in court.
That's fine.
Okay, so paragraph 1, no fee shall be collected or imposed in traffic, conservation, or in ordinance cases which do not require a court appearance and where fines are paid by mail or over the counter without a court appearance.
Correct.
Number 2, felony misdemeanor. Misdemeanor traffic offenses an amount which is on file in the county clerk and recorder's office.
Change to circuit clerk.
Everybody good with that? Number 3, all other traffic, local and county ordinances and conservation cases, an amount which is on file in the county clerk and recorder's office.
Same, circuit clerk.
So paragraph D, the clerk of the circuit court of the county shall collect fees pursuant to the schedule in subsection C of this section and shall remit said fees to the treasurer of said county as expeditiously as possible, not less than monthly.
She does that.
In paragraph E, separate revenue and expenditure line items as part of the sheriff's budget, known as the court security fee, shall be established, and the treasurer shall account for all fees remitted by the circuit court pursuant to this resolution, and all such funds shall be reserved for and only expended for expenses incurred by the sheriff in carrying out his duties pursuant to state statutes.
That's fine.
Paragraph F, the circuit clerk, sheriff, and treasurer of this county shall provide an accounting of said fees and expenditures on an annual basis to the chief judge of the circuit in a manner and form as directed by said chief judge.
I doubt that that's done. If it is, I'm not aware of it, but we don't need to change it.
If it isn't done, I mean, do we have to have it in there?
Well, maybe a future chief judge will want it.
Can I ask a question? What are these fees anyway?
Well, I mean, anytime you file any kind of a small claim or a divorce or a lawsuit, you have to pay a fee for that. There's filing fees. And these filing fees are broken down to various subsections as to get those fees.
Okay,
They call
I
them
know,
clerk
I know
costs.
of cases where there's an alimony or whatever it is, has to be paid to the county and distributed to the other party. Is there fees involved in that?
I mean, like restitution or, I mean, alimony is stuff which is now called
Maintenance or?
maintenance, yeah, maintenance. But not the divorce business too. So maintenance,
Once you're in one, you remember it forever.
it never goes away, doesn't it? So maintenance or alimony generally, I don't know if it goes to the state distribution units for child support. I don't know how that's done. I mean, I've been out of it so long, I have no idea how that works.
So I imagine there is a fee every time you take
I
money
have-
in and pay.
I
money
have
out.
no idea. That's a question Lisa's gonna have to answer, but it doesn't involve me, so I have no idea.
Who in the world is it involved?
What do you mean?
It involves the two people who are paying.
Right, absolutely. I
County
mean,
clerk is.
There has to be authority for the
That's
expenditure.
what we call
I have no idea.
moving along, we got a lot to do.
Well, that's.
I understand your question. This last one then, reading the way I read this,
Oh, here we go.
it's up to the chief judge whether he wants to have that information.
I think so, yeah. I mean, and maybe they do, John. I don't know. I mean, I don't know that they do because it doesn't involve me, but they may
As
do.
long as it's up to the chief judge to do it, whether he wants to or not.
Yes.
Okay, section 14-2, maintenance and child support payments administration fee. There shall be assessed against the respondent in any order of maintenance or child support an annual fee which is on file in the county clerk and recorder's office to be collected by the clerk of the circuit court of the county as cost for administering the collection and disbursement of maintenance and child support payments. Such fee shall be in addition to and separate from amounts ordered to be paid as maintenance or child support.
Yeah, that's up to Lisa to
That
collect
answered
that.
my question.
Yeah, that's your, there's your answer. I mean,
Yeah.
it's assessed, whether she collects it or not, I don't know.
I never got involved in that because I always kept my payment ahead.
The question here has,
But I was threatened with it every little bit.
It's still appropriate to have that,
is it appropriate to be on file in the county clerk and recorder's office?
not county
I
clerk.
wanted to know whether they had on to it.
Oh, it does say county clerk. No, county clerk should be circuit clerk.
Subparagraph B, the clerk of the circuit court of the county shall establish and maintain a separate fund for the deposit of the additional charge created here entitled Maintenance and Child Support Collection Fund, of which the clerk shall be the custodian. Ex officio to be used by the said clerk to further maintenance and child support collection efforts in his office.
That's fine. And just an additional comment on these county clerk and recorders references on all of these. I think if any of these are supported by a county ordinance that's required of the county to have an ordinance on file, then your county clerk is going to need a copy of that. But otherwise, your circuit clerk should be the reference point for what these fees are.
There's a reference on these to an county ordinance.
Pardon?
There is a reference here
Correct.
to a county ordinance.
Right.
In this case, it's ordinance 89-9. That's,
That's a long time ago.
goes back to your time.
Yeah, we'd have to check with Lisa to see if this has been updated. I'm sure it has been past 35 years. I don't know. I don't deal with this.
It
So,
might be a good idea to do that. Again, Brian says she doesn't have any. Maybe we need to check with her further. Maybe she needs to check with it. Maybe she has it in some of her old records.
yeah. Well, or her and Lisa can get together and decide between, what they have between the two of them.
Our interest is having this book to be as accurate as possible, so
Right.
serve as a reference point for everything we do. Not just the county board, but the whole county, really.
Right.
Okay, section 14-3, court document fee. The clerk of the county circuit court is hereby directed to collect a court document fee which is on file in the county clerk and recorder's office to be paid as provided. 75 ILCS 105/27-3C.
I need to look at that statute, which I don't have in front of me.
Should we change to on file in the county clerk and recorder's
Well,
office?
depending on what that statute says. If that statute references that it's got to be on file with the county clerk, then we need to keep it that way. I don't know, do we have a set of statute books?
Not in this room right now.
Not in this building. Do we have anything in this building?
Unless the county clerk has it, we don't have it. We don't have it in our office, do we?
Let me check with Brian, just let me look that up. I know that she does have statute books.
She should.
Want an intermission? Want to go into intermission? Right, till it comes back. Okay, then we're good.
Yeah, I can stretch it.
We are back then. Pop in the hallway before I do something.
I suppose that some of these things, like this section that we're looking at right now, we could just ask the state's attorney to go through it and be participating. But on the other hand, I think the benefit of for us to participate as well. Especially since the county clerk says she doesn't have a lot of these things on file. Maybe she should, and maybe she shouldn't.
That's only 16 years old. Look at through. Oh.
How old is the one over in the courthouse?
Well, they're up to date. Slow, but not that slow. It's referencing clerks, but it's not. It doesn't say circuit clerk, it doesn't say county clerk, so. Yeah, this is all regarding circuit clerks. County clerk is really gonna only be responsible for the keeper of ordinance records, not for anything regarding Lisa Hines' responsibilities. She would have a total separation from whatever Lisa collects. So,
This one way down in the end references ordinance 2014-7.
right, that would,
Referencing an ordinance that's 10 years old.
right. And it might be a fee that got established at that time. I don't know.
That's one of the questions and one of the reasons for going through this. If we have fees, are the fees up to date?
I haven't done a fee ordinance in years.
I mean, who's responsible for setting the fees?
Your clerk is.
Most of that, isn't it mandated kind of by the state?
It
If
is.
I remember right.
These would be questions for Lisa Hines to answer as to what she has on file with these fees. I mean, my guess is she's up to date on all of this, but, you know, on getting into the woods as to whether these are currently up to date, I don't know.
I guess we hope that she's up to date on them, but our book needs to be up to date too.
Right, so I can ask her about these particular fees. Because I know in the past, I mean, particularly even when Arlene, the circuit clerk, I mean, whenever there was any kind of a necessity for a fee increase, we always made sure it got done and put it through the county board. I haven't done one, like I said, in years, but I need to check on that to make sure that something needs to be updated.
Yeah, and I remember from judicial committee, Lisa's, I've asked her when I was there, and I think, yeah, that's, you know, are all the fees up to date? Are we charging as much as we can?
Right.
Cover our costs and so forth.
And she's always been very good about making sure an ordinance gets done if it needs to be done. So I'll just double check with her to make sure that this is up to date.
I'm just, I guess in my feeble memory, I'm not sure I recall us doing any ordinances for that sort of thing.
Not for a long time. Yes.
So maybe it needs to be done.
I'll check into it. Yeah.
So we only review this book once in a while. If the fee is updated and there's an ordinance, and we don't want to go through publishing the whole book, we just insert a paper that says this was updated on this date.
I mean, we've done that in the past.
What we were supposed to do this morning, and I don't know why Brian isn't here, but she was gonna talk to us about this book and what it's gonna cost us to get it updated. We've got the information there. Let's look at that. We'll get that in the last few minutes of our.
I think we went 30 years between updates last time, so we're only 10 years into this. So, again,
We were
In my view, 10 years is too long in the first place. I think it's time for sure.
Yeah.
Okay, going on to subparagraph B, the fee shall be paid at the time of the filing of the first pleading, paper, or other appearance filed by each party in all civil cases or by the defendant in each felony, misdemeanor, traffic ordinance, or conservation matter on a judgment of guilty or grant of supervision. If they don't pay it at the time of the first filing, what happens? They don't get their hearing in the court.
correct. Yeah, nothing gets filed.
So paragraph C, a court document fee shall not be charged on any matter coming to the circuit court on a change of venue or in any proceeding to review the decision of any administrative officer, agency, or body.
No change.
So paragraph D, court document fees shall be remitted monthly by the circuit clerk to the county treasurer to be retained in a special fund designated as the court document storage fund.
I presume that's being done. No, but no change.
So paragraph E, expenditures from the court document storage fund shall be made for the purpose and in the manner provided in 705 ILCS 105/27-.3C as now or hereafter amended. That's what you were just looking at a minute ago.
Correct.
It tells you how to spend the money.
It's $1 to $15. I don't know what she is charging, I presume $15, but I don't know. As of 2008.
Be a good question to ask her.
I'll check it out.
Section 14-4, court notice fees pursuant to the statutory authority in 705 ILCS /27.1A parentheses A. The circuit clerk's fee for the mailing of court notices is on file in the county clerk and recorder's office.
I think that would pertain to an ordinance again. I wouldn't make a change to this because ordinances have to be on file with the county clerk. So, to me, that's fine.
This one refers to ordinance number 209-6 from September 8th of 2009.
Right, so whether that needs to be updated, I don't know.
I guess the fee needs to be updated. If the fee was established by that ordinance that long ago, it probably should be noticed. If it hasn't been.
Right.
Okay, section 14-5, court filing fees. By authority in 705 ILCS 105/27.1A, there's hereby imposed for the filing of the first pleading, paper, or other appearances filed by each party in all civil cases in the county and in the county circuit clerk is hereby authorized to collect a fee which is on file in the county clerk and recorder's office for the filing of each of the following items. And we got a whole long list of stuff here. Civil cases.
Yeah, the problem with that reference is that's for counties population 180,000 over, but less than 500,000. So I don't know that this is applicable.
This whole schedule of fees is out.
I don't know about the fees, but the statutory references counties over 180,000, but not more than 500,000.
Don't they have one for counties with less than that?
It says in this, the fees of the clerks of the circuit court in all counties having a population of not more than 500,000 inhabitants. So the title says counties over 180 but less than 500. Then you go into the body of it and it talks about counties under 500,000 inhabitants. And then it gives the schedules that you see. So that doesn't seem to be making sense, but we'll go with it.
What kind of fees are we charging right now?
Again, I have no idea, John. That is outside of my bailiwick. These are all questions Lisa Hines should be answering. I have no idea.
Next page is a whole bunch more. Some of these copies of marriage records, copies of birth records, I think that's all done in the county clerk's office. The circuit clerk doesn't have anything to do with that. That's
The only thing the circuit clerk does is refer everybody to the county clerk's office.
in there that way. Needs to be something that I down. We'll go on to section 14-6, electronic citation fee. The county circuit clerk shall be authorized to charge and collect an electronic citation fee pursuant to 705 ILCS 105/27-3, in the amount which is on file in the county clerk and recorder's office, paid by defendants who receive judgments of guilt or grants, court supervision, in all traffic misdemeanor, municipal ordinance, or conservation cases.
Okay, that statutory reference is incorrect, because that reference is, actually the one I'm looking at references compensation of your circuit clerk. So that needs to be changed. I think it should be changed to the 705 ILCS 105/27-27.1A.
Okay, going on there, section 14-7, this sounds good. Rate to be charged gainfully employed offenders imprisoned in the county jail. Every offender gainfully employed while incarcerated in the county jail, including offenders who are sentenced to periodic imprisonment for weekends only, shall pay a fee for room and board each week to the clerk of the circuit court on a day designated by the clerk of the circuit court, a sum equal to the amount which is on file in the county clerk and recorder's office for each day upon which such offender is so incarcerated.
That's a sheriff question. I don't know. I know that they charge periodic imprisonment. There is a fee for that. So if you're just doing weekends or periodic days, then they do charge a fee for that. As far as those who are sentenced to, say, a 30-day sentence or gainfully employed, I'm not aware that there's a fee being collected for that. So, but if so, we need to have a statutory reference too. I don't see one. Let's scroll down.
Going on, subparagraph B says, upon certification by the sheriff of the county, the circuit clerk that said sheriff can administer the collection and distribution of funds as required by 730 ILCS 5/5-7-6 as provided in subsection D of such statute. The sheriff of the county is hereby authorized to assume such responsibilities for the collection and distribution of funds pursuant to 730 ILCS 5/5-7-6. Then underneath it, we got county ordinance number 95-23.
I know nothing about that. So that would be a sheriff question.
Here's one for the state's attorney. Section 14-8, State's Attorney Records Automation Funds Fee. State's attorney shall be entitled to a fee, the amount of which is on file in the county clerk and recorder's office, to be paid by the defendant on a judgment of guilty or grant of supervision for a violation of any provision of the Illinois Vehicle Code or any felony, misdemeanor, petty offense. Discharge the expenses of the state's attorney's office for establishing and maintaining automated record-keeping systems. The fee shall be remitted monthly to the county treasurer to be deposited by him into a special fund designated as the state's attorney records automation fund. Expenditures from this fund may be made by the state's attorney for hardware, software, research and development costs, and personnel related thereto. The state's attorney records automation fund is authorized in 5 ILCS 5/4-2002 and is hereby created.
I specifically remember doing that ordinance. I know that exists. I have a copy of that in my office.
It doesn't need to be updated, it's ordinance from 2012.
The only thing would be the fee that's collected. I don't know, and that's articulated in that ordinance. I don't know that that's ever been increased, but I'd have to ask Lisa about that. I know that fee is being collected though.
So is that where the money would come for processing like body cameras and stuff like that?
Body cameras, no, because that's for law enforcement. So this would be for computers, electronic equipment, hardware, software. Research would be Westlaw, when you did that type of expenditure, development costs, personnel related thereto. Development costs could be continuing legal education, I think. It's kind of loosely defined, I think, so it's pretty broad. I don't think it means I can give raises out of that. I don't think that's what it means, but I think it's expenditures for improvements.
Okay, well, that takes care of that chapter. Chapter 16 is the next chapter. We did go over parts of that chapter with Mr. Anderson because they apply to him. However, the last sections in that chapter, article, I believe it is, nuisances. Mr. Anderson doesn't know anything about nuisances.
I do. I filed them occasionally.
This is section 16-56. Purpose of this chapter, the term nuisance is hereby defined as any person doing a lawful act or omitting to perform a duty or suffering or permitting any condition or thing to be or exist which act, omission, condition, or thing either injures or endangers the comfort, repose, health, or safety of others, offends decency, is offensive to the senses, lawfully interferes with, obstructs, or tends to obstruct or renders dangerous for passage any public or private street, highway, sidewalk, stream, ditch, or drainage, in any way renders other persons insecure in life, use of property, or essentially interferes with the comfortable enjoyment of life, property, or tends to depreciate the value of the property of others.
That is beautifully vague, isn't it?
Well, it is, but the last one really sounds to me like anybody that doesn't like the wind farm has got a big complaint.
It's whatever you want it to be, because it's so vague. I can't believe, I think if it ever got challenged, it would be challenged successfully for vagueness. But, you know, it's all a matter of discretion and how you use it, of course. So I'm pretty jealous of what I do with how I enforce nuisances in general that come to me. So I use it through the letter. You know, I sign letters, I write letters saying, cut this
And I
crap
think
out.
we're comfortable with that, it's just a question of, are you comfortable with the way this is written? Do you think it needs to be changed in any way, shape, or form?
No, I mean, it offers a ton of discretion to the person enforcing this ordinance, so, which usually is the state's attorney's office. I don't think Mike Quinlan is gonna be any different than I am as far as how this gets defined and enforced.
Okay, we can go on here to section 16-57, illustrated enumeration. The maintenance, using, placing, depositing, leaving, or permitting to be or remain on any public or private property of any of the following items, conditions, or actions are hereby declared to be constitute a nuisance, provided, however, this enumeration shall not be deemed or construed to be conclusive, limiting, or restrictive. 1, noxious weeds or other rank vegetation. I think we got a few weeds growing in this county somewhere.
The problem with all of this, as you read it, is it's fine. But how do you, and it can be enforceable through the court system, and years ago I did do a couple of condemnations, 20 plus years ago. But that's when the county had a little bit more money to enforce condemnations and enforce these kinds of nuisance regulations. I mean, there's all kinds of nuisances out there, abandoned buildings, cars that are, junk cars that are on people's properties, and refuse and so forth. There's all kinds of that in our county. How do we enforce that? We just don't have the money to do it.
We even have people living in some of those conditions.
Absolutely, but you know, I can probably name 5 or 6 houses that absolutely need to come down and cleaned up, barns and other junk. But we just don't have the money to enforce it.
Local people used to deal with that, and the local police used to deal with that
Yeah.
in municipalities. And now that the county has got jurisdiction, they always have that jurisdiction, but now that they're taking over most of the cities and towns in Iroquois County, they don't have time to enforce these nuisances. Absolutely don't.
Well, just off the top of my head, I mean, I know there's a house up north on Route 1 here between Watsika and St. Anne. It's Wisniewski, Leonard Wisniewski built that house. Never finished it. It's not falling down, but it looks terrible. And at one time, it's kind of cleaned up now. It looks like somebody perhaps has bought it and they're fixing it up. But it looked dilapidated for years. And I know people wanted me to do something about it, and I'd love to, but there's no money to do anything to condemn it or to require compliance. Same thing in Lahogue. There's a house where a tree fell on it, I don't know, 15 years ago. Remember that? It's still there. I mean, it hasn't been touched. You practically can't see it because of the weeds and the vegetation have grown up around it, but it's still there.
Interestingly enough, there is a state program where they have some grants that are available for that purpose. And I'm aware of it, but we just have not had enough time to look into it and determine how that we might appropriate that here. I believe the city of Paxton is one that has done that, and they've got a program going where they're using some of that grant money for that purpose. Again, if we had some of these other things that keep cropping up, didn't crop up, I'd be able to address them.
Yeah, there's a lot of enforcement. There's a lot of unenforced properties out there that need enforcement that we just haven't had the money to do, to enforce compliance.
I don't know if there's any reason to read this whole list. I mean, if you,
That's the timing, there's some money didn't drop there because there's some of it that was started and never finished.
Well, one time I had a father who was the county engineer who provided some dump trucks to clean some places up. So we don't do that anymore, obviously, and haven't had that since 2006, so. That's
The grant money covered
county highway covered that. That was just the thing that he and I had that we were able to do, but, you know, ever since he retired, I never asked Joel to do that, and, you know, we just really haven't had the money to pursue it.
Well, I do think that there is some of that done, and so, you know, like the second one there, accumulation of rubbish and trash.
Right.
The township supervisors and road commissioners do clean up some of the stuff in the ditches and that sort of thing.
Right.
Beyond that, I know there was a house in Del Rey that was abandoned and had trees growing up, saplings all around it. Somebody had enough money, that's not there anymore.
Yeah.
I don't know what process by which they got rid of it, but I know that's one of the things that was done.
The Stevens property outside of Loda was, you know, dilapidated for years. You had, I think, the mayor or township commissioner talked to me about that. Again, I'd love, and I even have a judgment against them that I got in 2010 to get that cleaned up. But, you know, it's an unenforceable judgment because to force them to clean it up means we need to spend some money to do it. It's just we've never had it. Well, particularly, look at 2010, we're in a financial crisis. State of Illinois, and particularly our county, were laying off police officers back then. So for me to spend money to.
If you had the money, could you have done it and then put a lien on the property?
That's what you do. Yes, absolutely. Yeah. And then you enforce
You
that.
had grant money to do it.
Right. We just need to upfront that money to get the property cleaned, and then we put a lien on the property. Yeah.
But there's a few of them around.
There still are.
Some of them are abandoned properties. If you put a lien on it, it's the only way you'll ever get your money back if it's through a tax sale.
Right. It's a long process.
If it ever sells, you get something back.
Sure. Yeah. And you clean the property, you know, clean the county. And it sends a message, you know, that the county is doing something about dilapidated
Even if you
properties.
didn't get the amount, would that clear up the title?
And so, I'm sorry.
If you got some money back from that, would that free up the title though? You couldn't get it anymore? If it was sold?
Yeah, I mean, the lien would have to be satisfied, whoever buys it. So the county could compromise on the amount of the lien that we have against
I
it,
see.
sure, against any future buyer. We could always make a deal. I mean, we've done that, I think, down in Beaverville on some of the properties that we've given to the conservation people. So we've just donated those properties.
Do you think it's necessary for us to go through the rest of this section on these nuisances? Is that, I mean,
It's all, to me, it's self-explanatory. I think it's pretty obvious, and it just leaves a lot to our discretion as to how it's to be enforced.
it pretty well describes the whole process,
I think so.
including what Charlie was talking about, or by filing a lien, all that.
Yeah.
In here. Right. Article 4 talks about a chronic nuisance property. How is that different from a nuisance? Let's talk about that. The following words, terms, and phrases when used in this article shall have the meanings described for them in this section, except where the context clearly indicates a different meaning. Chronic nuisance property means property on which 3 or more behaviors listed below have occurred during any 60-day period as a result of any 3 separate factual events that have been independently investigated by any law enforcement agency.
Yeah, so you're talking about criminal offenses and all of those subparagraphs. And so what you're talking about is a 60-day period if there are 3 or more disorderly conducts at 804 South 4th Street in Watseka, which is often, that's where I live. So there's a lot of disorderly conduct that goes on there. But I mean, so I guess, you know, you could enforce a nuisance violation against that particular property based on these criminal offenses. I've never done it, to be honest, because if we're getting constant disorderly conduct arrests of a particular residence, then they go to jail. It resolves itself through the criminal process rather than the civil nuisance process.
I guess one of the things that concern me is that if we were if we were using this in some fashion or other, the 60-day period might become an issue because if Doug Geiger was the one doing this and he said, well, my 60 days is up next week, I'll wait till the following week to do it again. I'm not, because I'm starting afresh. That really defeats the purpose of this thing.
Well, what we'll do with Doug then is we'll file a petition to detain Doug, and then we'll hold him in the Iroquois County Jail. And then he'll be there for, well, he'll be entitled to a jury trial within 90 days, because that's our statute limit for speedy trial rights. So then we'll at least have Doug in jail for 90 days, and if we can get a sentence for disorderly conduct and get an additional 30 days out of it, that's what we'll do. That's our plan.
So I guess
When can we make that happen?
We're working on it.
I guess then that leads me to the question that if we're really not seeing a need for this, do we have to have this in the book?
I don't think we have to. Like I said, I've known this was available, but I've never used it because I'm so focused on the criminal.
Is there a reason to take it out?
I don't think it hurts having it in there.
It gives another avenue if that's necessary.
Right.
It maybe doesn't hurt to have it in there, but it might confuse somebody going down the road that isn't familiar with this book. Oh,
Well, who's going to be the one enforcing it? Your state's attorney's going to be the one enforcing it. So I don't see
your new state's attorney might look at this and
He
say,
might. He should be here saying, I want that in because I'm planning on using that. But Mike's not here today, so he can't weigh in on this.
I guess for the time being, we'll leave it in there.
I don't think it hurts anything. It's an extra tool in the toolbox.
It's the next section that I wanted to go over with you was number 22, which is the health department. And I know you're not the attorney for the health department, but I guess the question that I have here, we don't have a whole lot in here on the health department. Should we have more or not? Is really the question I have, because it just says we establish a county health department, and then it says we establish a board of health. And that's all this section says. Is that really what we want in this book?
Well, I mean, so what's come up in the past few years is, unfortunately, county board having to get involved with our administrator and employee relations. So it may not be a bad idea to have something in there to say that the county health department follows the personnel policies or personnel manual of the county. And just so that it's clear that that's where they go to when they want to get some answers for.
Is that something we can do, or is it, I know they do it, but that's my understanding, it's because they chose to do that, not write their own.
Well, they chose to adopt the county's personnel policy, and our policy, Amanda can help me out with this. Basically, if the administrator is the person who needs some kind of discipline, then, or at least an inquiry by a complaint from an employee, goes to the Policy and Procedure Committee. And that's part of our policy, right? Which we followed. Do we want to have something like that in there? I mean, it's really not, we could, probably should.
Well, there's also the fact of the matter that we provide them space in this building at no charge.
Right.
On the other hand, they do contribute some money to the general fund as an offset of that. And then we also provide the services of our treasurer, our finance office, and our HR department as well at no charge. So I'm not sure whether these things should be enumerated in there or not. We have a lot of things in other sections where we talk about how things are organized or set up. And I guess that's the question here, should we delve into that with the health department?
I think we should.
This was prepared at the time when the health department was just forming.
Correct.
And at that time, I can understand that some of these things weren't clearly understood or enumerated.
Right. And now we have 10 years of experience as to what we feel we need. So I do think we need more articulation under this chapter of, rules and responsibilities and expectations.
Something like any or more contracts need to go through the state's attorney, not just done by the board.
Things like that.
Well, I think we also have to be mindful of state statutes which authorize, what the responsibility of the county board is, what the responsibility of the Board of Health is, and so forth, because there are things that the Board of Health has sole responsibility to do.
Right, and there's a lot of attorney general opinions that delineate what the county board's responsibilities are versus the Board of Health responsibilities, things like that. So all of that needs to be taken into consideration and right.
So if we all agree we should do this, how are we gonna do it?
So it can be done in the next 66 days, John. I don't know if I can get it done. Not that I'm counting or anything, but there is that immovable object of retirement that.
I understand that aspect.
We're in the same boat, but I don't know that, I can work on it. I can at least, what I can do is I can at least put out an outline. That's what I can promise you I can do, is an outline of what I think needs to be done. I'll accumulate all the attorney general opinions that I have, look at the statutes, kind of put forth an outline that Mike or probably Jennifer Mainsberger will put together.
I guess if you work on it, we can work on you in return.
I'm sure you will, Charlie. I'm sure. I'll get
I
those
don't want to
emails.
leave that out.
Where you at?
I don't want to leave that out. We gotta get the dagger in if we can.
Sure.
I'm sorry, I have to have fun with it.
That's all right. Point taken.
Okay, that's as far as we can go today on that book. We can resume at our next meeting.
I got that in there for so.
Yes. It's in the record too.
We wanna talk now
I
about,
go to the Supreme Court with it.
Charlie, we wanna talk now about the county clerk received for the processing of all this that we're talking about to the before. There are two things here, two ways that we can go about this. One called recodification, supplementation, anonymized code hosting services. Is probably the way that we need to go and to find a place here. It's gonna cost us $15,580. This other one, I don't quite understand. It says it's republication, supplementation, and online code hosting services. So they're not, the changes that we're talking about making here, went ahead and put in the book, that's $15,580.
It says online hosting will come along as the online hosting paid up for with that. Or
I think that there's an extra charge for that, but it outlines that in the schedule. Looks like this one, if I'm reading it right, the cost is $84.75. One-time cost. And there's schedule for other things for it as well. Unfortunately, we can't just take this and type it up ourselves. I guess we're required to have this outfit do it for us. This was done originally by a company called Municicode, and they've been taken over by the Civic Plus which he submitted these quotes to us. We obtained these quotes. I don't know that we need to make a decision today, but we need to do something pretty soon, provide some direction. And what's the best way, once we got all these changes we keep talking about every month, they're recorded in the minutes now and so forth. You get them into the book, and to get all the state statutes that are referenced updated. I believe that's part of what this Civics Plus will do. Part of the problem is gonna be determining how far we're gonna go with this book. I hate to tell you this, because we've been working on it for a long time, but we've only scratched the surface. It's a big book, there's a lot in there, some of which, as you know, as we've gone along, we've talked about, well, we need to go back and do this, or like today, we need to talk to Lisa Hines and different things. So there's a little bit of catch-up work that we have to do, but the other thing is, the last half of this book covers ordinances. All the zoning ordinances, all the other ordinances we have are in there. And to review all those and know if they're updated or update them, it's gonna be, there's a lot of work.
Wasn't the zoning committee working with that?
It's
Oh,
not-
we're working on a lot of stuff.
not all, I don't think they're all zoning ordinances. The point is, we're not gonna get this done this year. This is gonna be something that's gonna have to carry forward. But I think we need to understand what the costs are gonna be. We probably need to budget some money for it for the coming year. Nothing is budgeted at the present time, so this is something that the finance committee needs to look at next week.
Where would that be budgeted under, just out of the general fund?
Well, it would have to come out of the general fund. I'm not aware of any grant to pay for it, and I don't know that there's any other place.
It's too much here to study.
The only other place might possibly be used from ARPA money, if that's a permitted use. I don't know off the top of my head without checking on it.
This is a one-time fee. Next question.
Well, there's there's an option for, there's a one-time fee, and then there's this online hosting and other updates that are included, I believe, as options, so this can be going forward.
And there's no other option, but we have to use Surrey Post. That's the only company that does this.
As far as I know, it is, yes. Ray can answer that question. I don't know why she isn't here this morning. She must be ill or something.
She's not here,
She's,
usually on time.
yeah, she's comes to every meeting.
Doug, you got a comment? I'm sorry.
Doug?
In today's electronic world of publications, would it be worth talking to this company to see, could they update chapters for us? And then we receive, electronically, and therefore not have to tackle the whole book at one time.
Well, I don't know, I guess that's something that we could look into. I would imagine if that were the case, it's gonna be more expensive. But on the other hand, there might be some benefit for us to do it that way.
Or doable, right?
I think the way we've approached it thus far is to try and go through the book, which is, you could even say this is an initial review, trying to determine what sections in the book are obsolete, what sections in the book are the way we do in business today or need to be changed and so forth. It's obvious every time we look at a chapter, there's questions and comments that come up. There's things that are not the way we're doing them today that need to be changed. If we want the book to accurately reflect what we're doing or the way we think the county should be operated. And that's our responsibility as a board to do that. So that's the purpose in going through the book and so forth. Unfortunately, like I said, it's not something that's going to be done this year, so carrying over into the next year, it's going to be the responsibility of this committee to continue this process. It's a big job. There's no two ways about it, but If Brian was here, she probably could answer these questions better than I can as to exactly what role these people might play or what options we would have. I guess, not knowing her situation, we possibly could defer this to the finance committee meeting next Thursday.
Well, it really wasn't on our agenda today.
Yes, it is. Well, it's coming right down there, it says discussion of the county code manual. Discussion and action regarding proposals for updating the
Okay.
county code manual.
But that's what the other thing, but. Okay, so on a minute.
The point is, I think there's some information there that she might be able to enumerate and enlighten for us. So I guess it's up to you guys if you'd like us to have the finance committee review the matter.
Yeah.
It probably is something the finance committee needs to be aware of anyway. If we're gonna spend some money next year, there's gonna have to be provision in the budget for it. It's my intention to be at that finance committee meeting. I believe the county clerk will be there as well. If you think that would be the way to go. I don't know that we have to make a decision right away. That again, I'm not sure how long these proposals are good for. Could be something we could delay till we meet again next month.
Can like automation funds be used for this?
We don't have an automation fund.
No, but they touch every one of the different departments, so could their automation funds be pulled together to at least make part of the cost?
Historically, the county clerk and the circuit clerk have had the largest automation funds, and they have, when they have an excess, they have made some of those funds available to supplement our general fund. I believe you're more familiar with the budget situation this year than I am, because I wasn't at the last finance committee meeting, but is there those funds been allocated?
That was what's on the board there is everything that we kind of went through and cutting to balance the budget, so.
Are they going to be contributing?
It,
It has to be done pretty soon to get a month in.
well, at this time, there was some that had offered, but I don't know. That would be something Jill would probably do right off the top.
Well, I know that both county clerk and circuit clerk both said that they had money that's available, but I don't know that we needed it.
Yeah, I don't know if she was including that into our dollar totals or not.
If this is gonna be done next year, it's gonna have to be budgeted for someplace.
Basically, we need $15,000 to $20,000.
I think the $15,000 number is probably the best way for us to go to ensure getting a book that we don't have the things that we want.
As you said, we don't know how long the bid is good for, so trying to budget, we would probably budget a little more.
There might be something in there that even says how long the proposals are good for. I did not have a chance to really scan every page that carefully. I did go over it briefly with Brian 2 weeks ago. Thought she was gonna be here this morning, so I didn't, I devoted some of my time to other things.
Yeah, basically it says this is not binding, and then if it's accepted, that they reserve the right to negotiate for insurance or other things, and so there isn't In that
It's not
part,
spellbinding, is it?
it doesn't say a specific date that it expires, but it does say that they have the right to renegotiate it if it's accepted.
It's not binding. Usually those things.
Well, I guess put it on the agenda for the finance. And that it gives us the option to do something or not do something.
That's the best way to go.
I did finance.
As long as Bree is there. As long as Bree is there.
Well, or,
Because she needs to explain stuff to us, what's going on, because A, we only got one bid from one, or two bids from one company.
I'll be able to speak with her before then. She does say in this cover letter here that I'm not getting somebody from this outfit on Zoom that can talk to.
And then we need to check out finance, what funds would be available for this. And then get a solid number of what we're gonna have to pay for this.
well, what it says in there, they're not gonna give a solid number. Not until it's actually.
Then why would
Do
we
we know
go
what
for
we
it?
want
That's,
to can do?
They'll give a solid number after you.
We can always adopt an agenda, motion that we, not to exceed. We need to get some other things done.
there's
Before
more,
we get to that.
I agree, there's more involved than we're seeing today. Yeah, I'll definitely.
All in favor, say aye.
Aye.
Opposed, same sign. Okay, we will send that to the finance committee. Appointments, we have some appointments that will be made at the county board meeting. We have some correspondence to look at today. Pipeline safety. Central Illinois Action Agency. P&P Community College. PCI. Down in the landfill. Save that. West Farmer.
They just want some information for the pipeline.
September 21st meeting, I think we're gonna
I
make.
got it, it's still in my file.
Yeah, usually it's done after. This is the 23rd meeting at K&H, we're supposed to attend.
Doing the groundwater evaluation.
Ohio State.
They're gonna be doing a groundwater evaluation, geosyntech for the disposal over there by Donovan. That's.
Get that notification every year from the state.
We ever get paperwork saying what turned out of it?
Get that. On the record.
It was farm water. Oh, fresh, we can get open up.
This one here is fairly important one, this one. You can make sure that the zoning office is aware of it. What, 52, and what?
That's the whole one.
With it right there.
Yeah, I think that's the letter or the file.
America, huh?
Gee, what's none of those are right now, right? Amazing farm managers,
Is that
not
AT&T
this
too?
company, I don't know. That was more amazing than this one.
Bring issues.
Yeah, I was with it more amazing than that.
All we're gonna go. 196 feet.
I'm assuming they for county board members set up a fantastic organization. Really bad.
About 4 feet, huh? Great, right?
Accuse me of that in return.
New York. I get an email once a week, maybe twice.
Okay, while we're finishing up with that, we can go on to the claims. Everybody had a chance to look at the claims?
Who's that? Sharon?
Yes.
Oh,
Yes.
Whitlam?
Yes.
Sure.
Yes. Any old business to come before the committee this morning? Any new business? Motion to adjourn. Second by Mr. All. All in favor, say aye.
Aye.
We have plenty of business.